Welcome, everyone, to this explainer on understanding legal fees in Ontario. If you've ever tried to figure out exactly how much a legal matter might cost, you've probably found yourself wading into a pretty dense maze of opaque numbers and confusing terminology. It's totally normal to feel a bit lost. So today, we're taking a journey of discovery to demystify how billing actually works, looking really closely at the 2026 fee guidelines provided by the AI lawyer matching platform Overrun. We're going to explore not just the numbers themselves, but the really fascinating mechanics behind how legal professionals price their time and expertise.
Right off the bat, it's always helpful to set the stage with a quick disclaimer. Overrun is an innovative AI lawyer matching platform designed to connect individuals with legal professionals, and this explainer does not provide legal guides or legal advice. The fee rules we're exploring today are drawn from general information, including the Solicitors Act and the Law Society of Ontario's Rules of Professional Conduct. We just want to give you a clear, comforting, and observant look at the whole landscape of legal costs. Okay, here is our roadmap for today's explainer. We'll be going over the invisible price tag, a bet about time, decoding the retainer, the anatomy of a legal bill, when bills feel wrong, and finally, finding clarity with Overrun. Section 1. The invisible price tag, searching for a public rate in Ontario.
So, when starting a legal journey, the very first question is usually, well, how much does a lawyer actually cost per hour? But searching for a public rate in Ontario is kind of like a wild goose chase. There is no official fee schedule, there's no public register you can just look up. Private rates are set firm by firm, completely out of the public eye. However, the number $157.94 offers a really rare clue. This is literally the only published hourly rate for a lawyer in the entire province of Ontario. It's the top-tier rate that Legal Aid Ontario pays its roster lawyers as of April 2025. Now, this isn't a private market rate, and it certainly isn't what a private firm is going to quote you, because Legal Aid is a high-volume buyer, so the rate naturally sits lower. But it's incredibly useful for calibration. When a private quote arrives, having this baseline just helps you understand what an experienced lawyer's hour is worth to the province. That opens the door for some really thoughtful questions about the gap between this tariff and a private quote.
Section 2. A bet about time, how fee models allocate the risk of the unknown.
The thing is, because nobody selling legal work knows exactly how long a matter will take, maybe the other side delays, maybe a judge gets reassigned, a quote isn't really a fixed price. Instead, a legal fee is essentially a fascinating bet about time and unpredictable events. The real question we're answering is, who carries the risk of the unknown? With the hourly model, you're buying time in increments, which means you absorb the financial overrun if things take longer. With a flat fee, there's one agreed price up front, so the lawyer carries that overrun. That's exactly why they tend to price that risk into their initial quote. And finally, contingency means the lawyer takes a share of the recovery. Here, the lawyer carries the risk of the time spent, plus the total risk of losing the case entirely. Thinking about it this way completely shifts how you might evaluate a qual.
But it's worth keeping in mind that there are gentle boundaries around these models. For instance, the Solicitors Act in Ontario completely prohibits contingency fees in two major areas, which are criminal and family law matters. No matter how strong a family or criminal case appears to be, it is strictly excluded from a percentage of the recovery model, and the courts are quite firm on this. Even if a family firm tries to get creative and call it a results-achieved fee, the courts will strike it down if it acts at all like a contingency.
Section 3. Decoding the retainer, understanding the advance payment. This brings us to perhaps the single most common misunderstanding when entering into a legal agreement. People often hear a number for retainer and just assume they've been handed the final price tag for their entire legal matter. Actually, scratch that. It's really more like a deposit. A retainer is a refundable deposit held securely in a trust account. That money remains yours until the firm actually completes the work and bills against it. If your matter happens to settle early and there's an unused balance, that money comes right back to you. It's often really helpful to ask up front exactly what phase of work the retainer is expected to cover, just so there are no surprises when it eventually runs down.
Section 4. Anatomy of a legal bill, where the final numbers come from.
Okay, so we've started the journey, and now let's imagine we've arrived at the end of a legal matter. Reading a legal invoice as one giant number is a very quick way to feel a bit of sticker shock. Instead, it really helps to view the final bill as three distinct puzzle pieces. First, you have the fees, which are the lawyer's actual professional charges for their time. Second, we have disbursements. These are amounts the firm paid out to third parties on your behalf, like filing fees or couriers. And finally, the HST, which is the 13% tax application in Ontario. But wait a second, if you calculate 13% of just the fees, the final tax line often looks a bit higher. Why is that? Well, what is truly fascinating here is how the Canada Revenue Agency treats those disbursements we just talked about. The CRA divides them into two specific categories. If a disbursement is incurred as your agent, like a court filing fee where you are directly liable to the court, it's a straight reimbursement, and no HST applies. But if the firm incurs an expense as an input to their own service, like photocopying, couriers, or the lawyer's own travel, the CRA says HST absolutely does apply when they bill it back to you. So, that final tax line includes tax on the fees plus tax on those specific input disbursements.
Section 5. When bills feel wrong. Timeframes for a bill assessment.
Sometimes, despite all the clarity up front, a final account just feels unexpected. It's comforting to know that Ontario has a built-in safety net and specific mechanisms for clients to dispute a bill. But, and this is crucial, this system runs on a ticking clock. You have a very clear window at the 1-month mark to obtain an assessment on requisition, provided there are no special circumstances or disputes about the retainer itself. But once you hit that 12-month mark, the door effectively closes. An assessment at that point is only directed under special circumstances that you would have to prove to a court. Also, it's a great little detail to remember that paying the bill under protest does not automatically close this door. Section 6. Finding clarity with Overrun. Navigating the cost question with technology.
Now, understanding these models is wonderful, but trying to implement them when you actually need help can be pretty stressful. That's where the Overrun AI platform comes in. It's designed to take the friction right out of these conversations. By matching individuals with verified legal professionals completely for free, it allows you to step back and easily compare different fee models side by side. Because you're matched with a few different professionals for the exact same issue, you have the perfect, comfortable space to ask those vital questions about overruns right up front before you ever sign a retainer. It basically empowers you to make a choice based on clarity, rather than just feeling like you have to accept the very first estimate that comes your way. So as we wrap up this explainer today, I want to leave you with one final thought. When you're about to embark on a legal matter, the most empowering thing you can do isn't just asking for the hourly rate. It's asking about the structure. Consider this. What fee model best fits your unique legal journey? And realistically, who is best positioned to carry the risk of the unknown for you? Thank you so much for joining me today on this explainer. Keep exploring, keep asking great questions, and I will see you in the next one.